Honorable Justices of the Supreme Court. Hearing this court. I'll sit.
Please be seated. Good morning. Sorry, we're a little slow getting back from recess, but get your patience with us. Mr. Shima, I would ask that you would please call the 10:30 docket.
The 10:30 a.m. docket for Tuesday, March 28th, 2023 consists of one case. Appeal number 124254, Jason Unruh versus the City of Wichita et al., Sedgwick County, briefs both sides.
May it please the court. My name is Michael Jelka. I represent the appellant Jason Unruh, and Mark Schonifer is my co-counsel, who is also present in the courtroom.
May it please the court, David R. Cooper on behalf of the appellees, City of Wichita, Detective Dan Widener and Officer Brett Pierce. Present, ready to proceed.
Your Honor, that concludes our 10:30 docket.
Counsel, you may come forward and come to the podium.
May it please the court, Madam Chief Justice, members of the court. My name is Mike Jelka, and I represent the appellant Jason Unruh in this appeal. Now, in the Court of Appeals case,
If I can just stop you just to be sure, going to reserve rebuttal time.
thank you for your my omission here. I will reserve 2 minutes, Your Honor.
Thank you.
In the Court of Appeals case, underlying this case, the Court of Appeals discussed at great length the District of Columbia v. Chen case, which is a case that addresses situations involving police use of force in which both negligence and intentional tort claims are made. And in that case, Chen examined 2 lines of cases in which the plaintiffs allege both intentional tort and negligence cases. The first line of cases deals with where negligence claims fail because the plaintiffs did not specify a negligent act beyond the intentional use of force itself. And then in the second category of cases, the court examined cases where negligence claims and said they can be submitted where, say, assault and battery claims have been separately pled by the plaintiff that at a standard of care distinct from that of using excessive force is pled, and where the plaintiff points to acts constituting possible breaches of duty. Now, the Court of Appeals in our case found that our case fits in the first category. Our position in this appeal is that we fit in the second category of cases, and on that basis, it's what we seek reversal upon. Let me be clear that we do not argue that the intentional act of force in this case is also a negligent act. Instead, what we argue is that negligent acts that lead up to the intentional use of force may be delineated from the actual use of force itself. And that is what we claim is the basis of the second category of cases in Chen.
What is the legal duty then under that negligence theory?
Okay, in the first, there's 2 specific instances that I want to point you to, and I'll address both those. First is the deployment of the K-9 here. We have a K-9 policy, and we believe the facts in this case that are set forth, and it's it's paragraph 54 of the, our response to their statement of fact is the dog here deployed here without a command from its officer. And we claim that that is a negligent act that is separate and distinct from the actual use of force. The second would be, in this case, we have the officer misperceiving the facts here, namely that my client had a gun, when in fact my client did not have a gun. And we would view that as a duty to perceive the facts correctly, a duty of reasonable investigation. So those are the two separate duties that we believe are distinguished from the use of force itself. And as to the first one of those involving the dog, you'll see at page 14 of the Court of Appeals opinion, there's even a reference to an Arizona case, which is, the case would be Ryan. And the court talks about if, for example, there's evidence showing that the officer had unintentionally dropped Barry, that's the dog's leash, and that resulted in injuries, then a negligence claim may have been appropriate. We think that our case fits within that framework because after all, a dog, a canine, is a dangerous instrumentality that has to be within the control of human agency at all times. In this case, if you view the facts in the light most favorable to the plaintiff, which you must at this stage of the proceeding, allowing the dog to attack, and after all, it did maul my client for a period of 22 seconds, that we claim is separately actionable under a negligence theory and is distinct from the actual intent use of force here.
But underlying, I'm hearing the fact considerations that constitute a breach, but is it fair to say the duty at law that the officers had was just ordinary care? Is that the legal duty?
The legal theory with respect to the canine use, there's a separate policy on canine use that canines are not to be deployed without a specific command from their accompanying officer. And we would say that that duty exists independently of the use of force. And we think that is what gave rise to the claim here in this Arizona case that the Court of Appeals cites in its opinion. We think there's nothing, analytically, it's not anything, there's nothing distinct about dropping the leash and having the dog attack versus not giving an order and the dog attacking. We think those are analytically the same. And since we think it fit within a separate duty in the Arizona case, it ought to in this case.
A duty defined by policy of.
Yes, there is a policy that the Wichita Police Department has on canine use. And with respect to the second duty that identified, we think there is a separate common law duty about a police officer having to observe the facts correctly. And we think the Chin case is very instructive in this regard. The Chin case involves a case very similar to ours where you have police stopping a motorist, in this case for speeding, and an altercation later results. And the way the Court of Appeals from the District of Columbia framed this, they say the crux of Chin's claim is that the officers deliberately inflicted excessive force, and the evidence he presented at trial was the officers continuously assaulted him without provocation. Chin did not argue that the officers mistakenly or negligently thought Chin was armed. In our case, it's the opposite. Second, Chin did not allege the officers misperceived him as a threat. We think our case presents the opposite, where the officer did believe that Unruh, they misperceived Unruh as constituting a threat. So in this second line of Chin cases, they revolve around fact scenarios in which there's two different distinct versions of what happened. And that is what we are asserting is the case here is we have our version of facts, and the court actually must accept our version at this point in the proceeding, is that our client was surrendering and did not constitute a threat and did not have a gun. And we have the police version, which is that he did constitute a threat and we thought he did have a gun. At this point in the proceeding, we think the court has to accept our version of the facts as being for purposes of summary judgment. And we would distinguish, or we would say that this is what differentiates our case from the first line of Chen cases, or the Chen facts itself.
Let me back you up to the dog. It seems to me that, I guess I want both counsel to talk about the dog issue, because that to me is different than stomping, on somebody's head or punching him in the back. But the trial court granted summary judgment based upon the lack of plaintiff coming forward with any evidence to show that better or greater training or handling would have changed the result. I mean, I'm paraphrasing, but so you're at summary judgment at this point. You're not at pleading stage, you're at summary judgment. They file their motion, you're supposed to come forward with why facts support your side of the deal for purposes of presenting to. What facts do you have? Well, first, was the district court right? And I'm not doing this right. Did I correctly paraphrase the district court's ruling at summary judgment on the dog? And then what's wrong with the district court's ruling?
Okay, and if I'm looking here at paragraph 54 of our response to the motion for summary judgment, and during the deposition of the officer who handled the dog, he was asked, when did you give the command to the dog? And the response was, it from the video is actually as the dog is biting Jason. That would say that the command came, again, as he's actually biting my client. He didn't receive a command to deploy, and so we would interpret that answer to be that he deployed without a command. And as for we have alleged in the pretrial conference order that one of the negligence counts was the deployment of the dog here. So we point to that, and let me further goes on to say, he says, according to the video, the dog does engage prior to me giving him the actual command of verlorum, which apparently is the command activate this canine. So there we have it. He engages prior to the officer giving him the command.
Well, then taking this, I'm now looking at it, so I don't have to paraphrase it, but looking at the district court's ruling on this, it says, but there is simply no evidence that more or different training, and that's, to me, that's one thing, one bucket, or different handling by the officer would have produced a different result. You don't have any evidence about more or different training would have produced a different. Correct?
With respect to the training, our argument below was that the incident itself reflected a lack of training, but alternatively, we argued that the officer, irrespective of the training, was negligent in allowing the dog to deploy without
That
a
to me
command.
is the other aspect of the district court's ruling, which is the different handling by the officer. That's the other. You see how I'm dividing it up?
Right.
And I'm just trying to narrow our focus, and you don't have any evidence about more or different training, correct?
We do not.
Okay.
We do not. Now, it seems to me that the district court's ruling here was that we fell within the first category under Chen, that the intentional act and the negligent act were one and the same. And I am conceding at this point that if that is the case, then the framework of Chen would dictate affirming the lower court. But what I say to the court is that you can delineate the negligent act from the intentional act in this case, and specifically with respect to the dog, it's negligence for a dog to deploy without human direction here. And if it later leads then to injury, that is an actionable claim. Now, let me address a couple of other matters here. There's the Court of Appeals case Unruh Estate of Randolph, which is discussed at length in the Court of Appeals opinion below. And let me try to harmonize the holding here in Unruh Estate of Randolph with the way I would approach our case here. In Unruh Estate of Randolph, you have police called to a home in Wichita. A mentally ill family member comes out and has a knife in his hand and the police officer shoots him. It seems to us that the case in Randolph involved the plaintiff claiming that the negligent act was the act of shooting. And if that's the case, then the negligent act and the intentional act are one and the same thing. And under the holding of the first category of Chen cases, that's not actionable because you can't negligently commit an intentional tort. What's different about our case here is because in our case, there's a dispute about whether the suspect here is armed. There's no dispute in Unruh estate of Randolph that the plaintiff's decedent had a knife in hand. In our case, there is a dispute about whether the plaintiff is armed or not. In fact, he's not armed. And at the stage we're at, summary judgment, our argument is that the court has to accept that version of the facts that we are presenting.
There a dispute about, I understand he wasn't armed. The officer thought he was armed, but isn't it about the officer's perception of whether he was armed? And what, and I know we're at kind of the fact stage and maybe these are facts that needs to be established, but if I thought some of the evidence suggested that Mr. Unruh was a violent person, member of a gang, had been seen in possession of a firearm on numerous occasions. Why isn't that a part of the calculus of perceiving presence of a weapon?
Well, because
that's what it was a misperception of the presence of a firearm based on kind of the physical actions. But what about the kind of psychological, or maybe not psychological, but all the facts that the officer has to take into account when they're pursuing this guy?
It is true, Your Honor, that you have to look at what a reasonable officer would have perceived. And those facts can be taken into consideration, but they don't completely define. And it's not. I do agree with the idea that you can't just say he didn't have a gun, therefore the officer was wrong because he guessed wrong. Because it is the perception of what a reasonable officer would see. But again, at this stage of the proceeding, our evidence is that my client was in the act of surrendering. There were drugs, not a gun there, and that an officer seeing these facts in front of him should have seen that he did not have a gun. So at our stage of the proceeding, I mean, that may
Basically, what you're at this stage,
at trial, we have to prove these things with a jury instruction that's going to go that says that it's what a reasonable officer would perceive, not whether he turned out to be correct or not. So that's the way I approach that.
But there's no act with the brutality side of this thing. No act that gives rise to the officer having any kind of special duty here. Act is the physical force that gets applied.
The actionable act that we are claiming is the negligent act of misperceiving whether the defendant was armed here or not.
That's not an act. That's
Well,
an evaluation.
It's an evaluation. And in that respect, we think that the Washington Supreme Court's opinion in Beltran Serrano v. City of Tacoma is instructive on that particular situation. In that case, you had an officer encountering a mentally ill homeless man, sees him lying on his stomach, digging a hole. The person, the plaintiff, doesn't speak English. The officer radios back for a Spanish-speaking officer, and then the plaintiff gets scared and runs away, and the officer then shoots the plaintiff. There's a 37-second gap between the officer radioing for the Spanish-speaking officer and the actual shooting. And in that case, the Washington Supreme Court said that a negligence claim could be made on what occurred in that 37-second period. They said the officer failed to follow police practices designed to avoid using deadly force. And you had in that case, the city making essentially the same arguments that the city is making in this case.
I understand the facts in Beltran, though, that there were a series of acts by the officer the Beltran court said, acts gave rise to the duty, where here there's only the act of the use.
There is the act of the use of force, and my contention is that separate from that, you can delineate from that the officer's evaluation that preceded the use of force, and that can be independently actionable. If he incorrectly and unreasonably perceived that.
But that's your negligence. I mean, the evaluation part is what you're saying was done inappropriately.
Yeah.
But there's no other act, chain of event in the use of force here, other than the ultimate use of force. There wasn't anything else that happened. And as I read the case law, you've got to have an act that actually creates the special duty in order for you to start talking about negligence. That's what's kind of differentiating this here.
And what I would say is that I would again point you back to the Chin case, where the Chin court talks about how they did not argue that the officer mistakenly or negligently thought Chin was armed, and they do not allege the officers misperceived him as a threat. And we would take that paragraph from Chin to say that a mistake of fact, shall we say, an unreasonable mistake of fact, can separately give rise to a negligence claim that ultimately culminates in the intentional use of force. I mean, with respect to the stomping and the punching of my client, we do agree with the Washington Supreme Court's formulation that you have to be able to delineate acts leading up to the use of force from the use of force itself. So with respect to that, I do acknowledge that we have to be able to make that distinction. And that is the argument we present, the misperception of facts. Now, there's also in the Court of Appeals opinion in this case, a discussion of the long line of cases dealing with this topic of negligent use of force. And it's probably a little bit of a misnomer to call it negligent use of force. It's probably more accurately described as negligent acts in a single incident that later culminate in the use of force. Again, we're not saying that it's identical. We're not saying that an intentional act of using force can be negligent. We are saying that you have to be able to delineate those two. And to harmonize the law that the starting with Doffenbach and going up through a series of cases, the way we would say that the court should harmonize those cases is the Doffenbach case stands for cases that fit within the second category of Chin, cases where there are separate negligent acts that lead to the use of force. I mean, Doffenbach itself is the issue of whether the negligent act was the same as the intentional act is not squarely presented for decision. The holding of the case hinges on what's the appropriate standard of proof for a negligence claim. And the court holds that it's preponderance of the evidence, not clear and convincing. But all these cases that follow it, I think you can fit within the Chin framework. And again, ask, do they fit within this first category? Are they one and the same thing? Is the plaintiff just pleading the intentional act is a negligent act? Or is there something different? Namely, have we pled a separate and distinct negligent act that gives rise to a cause of action for negligence?
Just to sum up what you're saying. So the duty here, basically you're saying two duties. The canine policy, the duty is defined by the policy, and the duty of reasonable investigation.
Yes.
And that these officers violated those duties, right?
Yes.
Breached those duties, if we're going to use, the lingo, and caused damages. And the damages, so what are those elements? Tell me what the causation, what are the damages that were caused? So the damages are the intentional tort of excessive force?
No, Justice Stanridge. The damage here is that Cassius, without command from a human actor, deployed and mauled my client for 22 seconds. And my client suffered serious injuries. So the fact that he deployed without human intervention, we think is creates a causal chain. Now, I understand that there is also, I mean, at the point where he's mauling my client, I suppose the officers didn't give a command to stop, but I mean, the ball was set in motion here by the canine deploying without human intervention. And so we have a duty, don't deploy a dog without a human command, a breach of that duty. And we have 22 seconds of mauling of my client, which caused him serious injury. So that's how we
Okay.
analyze that part.
Okay, and then on the duty of reasonable investigation,
We have a duty to reasonably investigate. We have an officer failing to perceive my client was unarmed, which in turn led to additional force being used against my client.
okay,
Leading to him
so,
cause a subdural hematoma.
okay, so that's what I'm saying. The damage is excessive force being used. So the damage is actually the intentional tort, right? So that's what I don't understand is that we're kind of damage is an intentional tort. I'm not really
Sure.
getting. that.
Right, again, if we're still on the dog thing, on the
No, I
canine,
don't wanna
okay,
be on the
oh,
dog
okay.
I
we
get
move
the
on.
dog thing.
Okay, but the officer's failure to, under our view of the facts, to
Right.
correctly perceive the facts leads in turn to the additional force. And now, at this point, we have I agree that punching and kicking is an intentional act, but I'm saying that by misperceiving the facts, the officer set in motion a chain of events that culminates in the use of force, which causes serious injury, my
But
client.
under your theory, wouldn't the negligence damages terminate at the time the intentional tort begins?
Well, there's a doctrine in law, I think, called concurrent causation, which a court has to, where you have negligent acts and intentional acts both operating to bring an injury. And I guess the issue becomes, does the intentional tort at some point cut off the chain of events, which is, I guess, an issue the court is going to have to determine if the court reverses. It's not squarely presented, but I understand the point that both of you are making, that you're not claiming, you're implied in your question, is the idea that at some point a intentional act cuts off the consequences of the negligent act. And
You don't get hurt without the excessive force, the intentional
Right.
tort. You
But,
don't get hurt. You don't have damages.
but without the breach of duty setting this in motion, we never get to the excessive force. We never get to the intentional use of force.
Never get to damage either, because that's the point I think that colleagues are trying to make here. That there's no damage other than the excessive force, which is the tort from that chain of events.
And my response would be that if you misperceive the facts and believe a person is unreasonably believe that he is armed when he's not armed, and that leads to a decision to apply additional force, that can be linked back to your misperception of the facts. That would be my explanation for it.
Let me ask one other question, and this probably isn't in the record, but after reading all the briefs, my question is, not be fair, but is there a reason why this wasn't brought as an excessive force claim? Is it because the statute expired?
That seems to me to be the reason. Okay, I see my time is up. Thank you for your good questions.
Again, may it please the court, David R. Cooper on behalf of the appellees, City of Wichita, Detective Dan Widener and Officer Brett Pierce. The case that just got argued before the court seems to be a different one than was briefed or presented on. Arguments and authorities on the petition for review begins. This petition presents the issue of whether a claim of negligent use of force by a police officer exists. And we just heard close to 30 minutes of argument that that's not the issue in front of the court anymore. I'm a little discombobulated on how to present the argument that I had prepared to present today, because it's relatively simple. A battery is defined under Kansas law as the unprivileged touching or striking of one person by another done with the intent to bring about that contact, whether it's harmful or offensive. There is no question in the record that the acts by both Officer Pierce and Detective Widener in this case were intentional. Addressing the canine, Justice Biles, the record reflects that first, Detective Widener believed he had given the command to deploy the canine before the canine reached Mr. Unruh. And when presented the evidence, and what counsel read to you from the record is that at deposition, while watching the video, he said, I gave the command as he was beginning to bite. So we're still not separating the intent from what happened.
Counsel, let me jump in here and ask a series of questions that sort of has as its premise the idea that perhaps this discussion about intentional versus unintentional is something of a red herring in this case. And what I'm thinking of specifically are cases of alleged professional negligence, particularly medical malpractice. Why isn't this analogous to, for example, a claim that a physician breached his or her duty of care by misdiagnosing a patient and then performing some kind of medical procedure based on that misdiagnosis? I mean, certainly that kind of a negligence claim is permissible, and everyone would agree that the actual act was intentional. I mean, the doctor takes out the wrong kidney.
I grant you that.
That's a battery, right?
It is.
But we can still bring a negligence claim. Why isn't this just directly analogous to that kind of claim that there's really professional negligence here?
Well, I would suggest that's because the medical malpractice community hasn't caught on to the fact that that sort of a claim is actually barred by a 1-year statute of limitations.
Your argument here is that's actually not a claim under Kansas law. You cannot bring a negligence claim under Kansas law.
That it may be but the question is whether it's an intentional application of force that is harmful or offensive. And the question is that really a battery claim, or is that a professional negligence claim?
Well, I guess the point is, it strikes me, again, going back to where I began, that this hard, bright line between intentional and unintentional is at worst a red herring. At best, it's confusing. I mean, because what the case law is really talking about is the distinction between something that's a mistake, negligence, versus something that is not a mistake. That's slightly different from, look, the act was intentional. Well, of course the act was intentional. Let's say a lawyer comes up with a strategy and executes that strategy. It's all intentional. And then after the fact, the client sues and brings in experts to say that was a dumb strategy. I have an expert professor at Yale who says that lawyer breached the standard of care, fell below the professional standard of care. But the acts are all intentional.
That engrafts a different body of law onto the body of law of personal injury and bodily.
Well, I guess that's what I'm driving at, and I'll last question in the series of questions. How would you articulate the standard of care owed by a law enforcement officer to the general public?
That is going to be with respect to the particular issue presented.
No, just
But when
a
it comes to-
general standard of care. What is it?
Well, you've already written in the Reardon case, this body's already written that the standard of care is reasonable care under the circumstances.
Okay, and so why couldn't a plaintiff just simply say, there's one duty. The duty is to exercise reasonable care under the circumstances, period. And I have these set of facts, and I'm going to allege that these set of facts constitute a breach of that standard of care.
Because the law of Kansas is and has been that there's a distinction between negligence, which is the unintentional infliction of harm, versus the intentional torts of battery, assault, false arrest, and false imprisonment, where the act itself was intended, and it was intended to cause a species of the harm suffered, whether it was that degree or not. And Kansas cases going back over a century, the 1860 cases, the Lawrence and the Laurent and the Bynum cases from the 1800s talk about you didn't accidentally shoot that gun while you were a member of a posse, or you didn't actually shoot that gun in the middle of the night while you were helping the sheriff out. And the fact that you shot the wrong person or caused a degree of injury you didn't intend does not change the character of the act from intentional to unintentional. It was an intentional act subject to the 1-year statute of limitations. This court in Basket versus Scherzer said the same thing. You didn't accidentally throw that punch. And the way the law works is that your intent to throw the punch at the guy you were fighting with, but you broke the teeth of his mother, who was trying to break up the fight, that intent transferred, and it's a battery subject to a 1-year statute of limitations, even though the case was pled 9 ways to Nancy of it, you didn't mean to do what happened. The McElhenney case as well is directly on point, and it distinguishes the difference between this intentional versus unintentional consequences of the act. Where the youth was driving up and said, I was just trying to park, but really close to her. And when I parked on her foot, that was an accident. But there was evidence that no, he meant to bump her, but he parked on her foot instead. And that caused way more injury than he intended. And that, in that case, it was held, we're going to let a jury decide, was it an accident or was it on purpose? Same injury, but was it in terms of the cases that are cited in the briefs and discussed in some of the cases, the Clark versus Thomas case is a very good example.
I think there's a difference between these two scenarios. First scenario, the law enforcement officer testifies, boy, I thought that person had a gun, so I beat him up. I'll use that phrase. I
did what I did.
I did what I did. Thank you. Versus the officer who says, yeah, I knew he didn't have a gun, but I did what I did anyway. Is there a difference between those two scenarios?
No, because both of those are intentional employments of force.
So the mistake, I mean, you would agree, I think, that in the first officer made a mistake. The second officer did not make a mistake. The first officer says, I thought he had a gun and I did what I did. The second, and the did what he did is identical. And the second officer says, yeah, I knew he didn't have a gun. I did what I did anyway.
Are you talking about the facts of this case or just
Any facts, whatever facts you want to imagine. I'm drawing attention to the distinction between mistake, not mistake.
Well,
whereas the act is the same.
I agree that the act is the same. The act is the intentional employment of force. Whether you were right or whether you were wrong or whether you did it with malice, that's 3 different things, and it matters.
I just wanted you to focus on mistake or not mistake. The
Then that comes in the privilege analysis. Was it a reasonable use of force? Yes or no?
Well, it strikes me that your argument essentially boils down to the law gives no recourse to a person who is damaged as a result of that mistake that I described.
That's not accurate.
Why not?
If it was an unreasonable mistake, the law absolutely gives recourse through the cause of action for battery or.
It doesn't matter whether it's a mistake or not, because it's a battery. The only reason a law enforcement officer gets exonerated, let's say, is because of this notion of a privilege, which is something that comes after the fact, right?
Precedes the fact. There are privileged touchings. People can agree to fight each other. It's called boxing. Or it's let's go out. It's the school. Let's go out behind out behind the school after recess. Sorts of things. There are such things as consensual events where people get battered, get thumped on it because the battery is if it's unprivileged. So the privilege exists. And it exists both in the restatement, it exists in Kansas statutes with respect to the privilege to use reasonable force, and that reasonableness calculus depends on the reasonable perceptions of the officer at the time the force is used without the benefit of 20/20 hindsight.
Okay.
And so it does, this is a battery. No question, this was an intentional deployment of force. This was an intentional deployment of the canine. That now whether the issue is, did the canine go for Jason Unruh before the command to deploy was given? That may be in dispute, but there is no dispute that the command had been given at the time the bite commenced. And he didn't accidentally use his foot. The accident was, it wound up on his head. I was going for his shoulder to keep that hand that was going under their car from reaching whatever the heck that is under the car that I can't see. And okay, I, Detective Widener, feared that was a gun he was reaching for, and I was going to make sure that didn't happen. And the question on a battery claim, if it's timely, is presented to a jury as to whether that was a reasonable mistake or not. I thought he was armed, and that, again, to Justice Rosen's questions, all that went before that comes into that calculus as well, which is the fact that the officers knew they were staking out a methamphetamine house. This person left the methamphetamine house. This person went on a 10 to 11-minute chase through the pouring rain, throwing handfuls out of the bag of meth, the 1-pound bag of meth he had been carrying around, trying to get rid of the meth before this happened. So that, again, there's no question of intent. The fine line that's trying to be drawn here is, let's talk about the things that happened before that may have resulted in this use of force. And Justice Standridge, your question as well, and as well as yours, Justice Wilson, which is, and yours, Justice Bonds, is we're not separating the theory being advanced by the appellant here does not separate the intentional act from what went before, because the damage is the intentional act, the use of force. But there are circumstances, and there are cases, Kansas cases, and I know from my practice, recurring things that happen where this, the idea of negligence preceding a use of force can be directly related and causally connected. And the Titchener case, it's the unpublished Court of Appeals case cited in the briefs. There, the officer broke the gentleman's neck, but I was involved in that case early, and I know it was that happened because the gentleman had fled. They got him out of the car, and he was getting ready to handcuff him, and he slipped on ice, and his knee went on his jaw instead of next to his shoulder, broke his jaw. That was negligence. And in that circumstance, all those circumstances come together and comparative fault applies. And there are consequences for this battery versus negligence theory, which is When we're dealing with battery, comparative fault principles go out the window. And if it was excessive force and it exceeded the privilege, we bought all the damages. Whereas in a negligence case, we get to compare fault and compare the fault of the bad guy who did all these things, had a pound of meth, throwing it out the window, went on a 10-minute chase and didn't give up when his car crashed out.
So then it's negligence if it leads to an unintentional.
Now, let's talk about a real world example where negligence preceding the use of force led to the need to use that force. You can have the circumstance of a diabetic emergency or somebody suffering a medical disorder, usually a stroke, where they're behaving abnormally, and failure to proceed and get the treatment for that medical issue. This happens in jails a lot. And that person acts out, and then you wind up using force, causing some sort of injury that was avoidable, and it's a foreseeable act that this person's going to start acting irrationally if you don't get them the medical attention they need.
Why isn't that just what we have here, just a fact question, like what you just presented? That gets beyond summary judgment.
Because here there is no question that the act itself was intentional. And nothing the officer did before caused the need to use that. Where another example where negligence preceding a use of force can still result in. Again, it happens with alarming frequency. The officer rolls up on a fight in progress, doesn't put their car in park, gets out, starts to break up the fight, shoves somebody in front of their car, which happens to be moving. That's a negligence claim.
Why isn't professional judgment an act before?
Let me ask you this.
Well, you were saying there was no act before that caused the intentional act. And because you're trying to distinguish it between the diabetic and the rolling car. And I'm asking, why isn't professional judgment an act before?
Because that's all part and parcel of the reasonableness of the use of force. And I see I'm out of time, but if I do want to complete the thought at least. There is a lot of language, especially starting in Deffenbaugh, that carries through a whole lot of cases that talks about negligently using excessive forces. And the Chin case speaks to that, as well as the Court of Appeals decision. And what you're really talking about when you use that phraseology is that you used more than you really needed to. And this comes back to a thought that I had earlier about, and it matters because we're talking about the non-malice, non-wanton use of force, meaning, which using your example, Justice Stegall, is I knew he wasn't armed, but I shot him anyway. That's willful and wanton, and that is a different standard of care. That by definition exceeds the privilege to use force. And the question in here, we're not dealing with a question, and it's in the it's both in the Court of Appeals decision and the district court decision, that there is no evidence of malice or maliciousness here. And therefore, we're not dealing with that sort of standard of care, but it matters in terms of where the language of negligent use of force leading to excessive force is essentially, did you exceed the privilege? If you exceeded the privilege, it was unreasonable. And there's a lot of cases that discuss that as negligence. You went beyond your privilege. You didn't mean to, so it wasn't willful or wanton, but you did. And so if it wasn't willful or wanton, it must have been negligence. And absent further questions from the court, the prayer from the appellees is to both affirm the district court and the decision by the Court of Appeals, and this case to a final conclusion. Thank you.
Members of the court, I have a couple of points here to make in rebuttal. First, there was a suggestion at the beginning of my esteemed adversary's argument that we have somehow changed our theory. In fact, I think if you carefully look at our petition for review, we discussed the Beltran Serrano case. In some detail, we cited to the Chin case, so I wouldn't say that we actually hit our theory. Second,
Let me
Mr.
interrupt you there because I've got your petition for review in front of me because it was sparked by something Mr. Cooper said. And it did surprise me when we were talking about the dog. On page 7 of your petition for review, you state the decision by the officers to deploy the K9 Cassius was negligent and led to a serious injury comparable to the situation at Doffenbach. My point is, this petition for review talks about the decision to deploy, and that's different than the dog disobeying its training and mauling your client without a command.
That is true, Your Honor. I incorrectly stated things in my petition for review, and I want to focus on that point. Mr. Cooper raised it here in his presentation where he said that there was an intentional deployment of the K9. In fact, I think the evidence in this case is that the decision to deploy didn't come until the dog was actually biting my client. I mean, it was an after the fact decision, which we think the duty is to give a command before it bites the suspect in this case. So we think that characterization of an intentional deployment is not an accurate characterization of what occurred here. At least if there's a dispute on it, we can look at paragraph 54 of the response, and you have to view those facts in the light most favorable to my client.
Yeah, that's not really true here, though, because it's your obligation to tell us what went wrong at the Court of Appeals, and then that's our universe.
Okay.
And I think there's a reasonable argument here that you haven't brought to this court any issue about the dog packing when it didn't have a command to do it, because you said the decision by the officers to deploy negligent, and that to me is an active thing. They made a decision and the dog deployed. So I don't want to take up your time here, but I think there's a problem. That's what I'm saying.
Are there any other questions? Okay, thank you for your time, Your Honor.
For argument, and thank you to both counsel for your arguments today. We will take this appeal under advisement. The court is now in recess until 9 a.m. tomorrow morning.